Sells out. Yep.
All right. Well, hello everyone. Thanks for ending your week with us this afternoon. Yeah. So I'm Brett Ballew, and we have Jacob Anenzio here. We're both managing attorneys at the Washington State Office of Public Defense, and Brian keeps inviting us back to talk about this topic, and we've figured out a few different ways to talk about it. Some of it is just making it more interesting to us, but some of it is some changes in thinking as we've gone along. And so here you can kind of see some of the past titles. What the last one, the pain in the rump thing, actually came from a conference in 2014 where there were opportunities for child advocates to put notes down on a board, and Jacob and I walked past this one and started laughing, and I took a picture of it, and it's become a part of our routine for a while, because I think it's such a great question, right? Why do OPD counsel have to be a rude pain in the rump? And hopefully not rude, but pain in the rump, yeah, that's a part of the job. That's as you'll kind of see as we go along. So yeah, so we're going to talk a bit about that. We're going to talk a lot about how parents' attorneys think, how public defenders think, and how that's kind of a part of their makeup, and how that fits into this job. And I think that's really important, because if we know how all the different parties think about their job and how they go about it, how they feel about it, it also helps breed understanding. And the more that we understand one another, I think the easier it is for us to work together, particularly when we have conflict. So, but before we get to parent attorneys, let's talk about you for a moment. So in the chat, if you could just say why you do this work. Why is this important to you? And I'll be quiet to give you an opportunity to do that. So children are our future, giving kids a voice. What else? Give back. Yeah, so I can tell how important it is to make sure that kids can, a kid's voice is heard in this system, and how important that is, and how we want them to grow up and be productive adults, be kind adults. Yeah, so I'm really getting that how much you care about kids, and so you can kind of see how that motivates you guys. And as a parent's attorney, that's important to me, to know that that's where you're coming from. Maybe I disagree with you, but I realize or think about it. You know, maybe we get pretty angry with one another, but if I sit back and think about it for a moment, I can see that even though I don't agree with you, yeah, you care about kids. That's a big deal. That's an important thing. I think that's an important thing to a lot of people, including parents' attorneys. You would actually see, if I asked that question of parents' attorneys, some of that would definitely be in there, or caring about families. Okay, I'm gonna change this up now. I've got another thing to chat about. One word. Let's see, is it switch? There we go. In one word, describe your interactions with parents' attorneys in your counties. Super curious about this one. Great. Informative, that's interesting.
I want to know what county that is.
Upset. Pierce is informative. What's upset? What county's upset?
just sometimes what they want and what I want don't meet in the middle, so to speak.
Gotcha.
Limited, that's interesting.
Yeah.
Interesting.
Confusing, I get that.
Yeah.
Yeah, I will tell you that when we first started doing this, maybe I've got some, it's possible that there's some confirmation bias on my part, but it would have been a lot more negative, say, 8 or 9 years ago. Sometimes, yeah, this one's interesting. Sometimes adversarial, sometimes it feels like we're all on the same team. Yeah. Do you have any impressions of this, Jacob?
Oh, no, I generally, especially when someone, there's some anonymity to it, I thought it would be a little more adversarial, but it's good. Yeah.
Good.
You guys ever find yourself on the same side as the parent's attorney with the department on the other side, AG's on the other side? Yeah.
Sometimes.
When that happens, parents' attorneys are thrilled because y'all have a lot of sway with how things go, for sure.
I will say, and in some counties in particular, but a lot, again, 8, 9, 10 years ago, that would not have been true, or would have very rarely been true.
Yeah.
So I have some hope that we actually are becoming a more, we're becoming a better system. Yep. Oh, it's okay to disagree, remain civil. Perfect. Yep. All right. So now I'm going to talk a little bit about just kind of some foundational feelings that public defenders have, for the most part. Not all of us. We're not everybody isn't the same, but this is for the most part. These are some memes that come from the National Association of Public Defense, of which I'm a member.
Me too.
Okay. I'm not going to read all the words here, but you can kind of see the words that might be important. Abuse of power, poor people, Constitution, the end of racism, hope. Hope's a big one in public defense. I love the one on the left about don't do it for the thrill of victory. Victory rarely comes. Do it for love. Justice, self-respect, right? Defending the Constitution. Ooh, doggone it. Sorry. A little heavy on the click button. Really important that you learn that very early on as a parent's attorney or general public defender. You are not on the winning side. And probably for good reason. Like if we were on the winning side all the time, that would mean that all the time the state would be using its power wrongly. So that's not why you do it. I like the one on the right that talks about that's my identity. This isn't a job, it's my identity. What I do is I do these things, I defend people, I'm looking for justice. And it's not just, I just don't do it for a paycheck. I do it because that's who I am. There's a little bit of martyrdom in that. that'll cop to. But it's something like, it's that important, right? I went to law school. I could be making a lot of money doing other things, but I want to do this thing because the values are important. Then here's some fine-looking folks in other public defense agencies around the country, and we noticed that the words, right? Dignity, justice, hope, fairness, justice, dignity, right? The same words over and over again. Voice for the voiceless. I just noticed just this moment, right? That's a common value that we share, right?
Yep.
Voice for the voiceless, voice for children. That's interesting. Advocate for the poor, defenders for our community. So that kind of gives you an idea of the makeup of what we're trying to do. And I think another thing that I just now thought of was that I think a common complaint is that attorneys just want to win. And that's right. None of that was in here. In fact, one of our memes said, "Don't do it because you want to win, because you're not gonna." Right? That's not it. It's not that you just want. You're not trying to win. You're trying to defend someone. One more bit comes from history. A lot of times when people are talking about public defense in history, they talk about the Revolutionary War and John Adams defending the British soldiers in the Boston Massacre. But I'm going to change that up for a moment. I found something the other day out of the ABA journal where someone was talking about public defenders have to be zealots, like they're required to be zealots. I don't buy that. I don't think we have to be zealots. But that was kind of the take of this person. And they went back to a different time and place in history. In 1820, King George IV of England, he and his wife didn't get along. And so they lived apart. She lived in Italy. He lived, I think, in England. And they had lots of different romantic partners. And when it was time for him to be coronated, he said, "I don't want her to be coronated. I don't want her to be queen, Queen Caroline." And so Parliament had this long hearing where they trotted out for days, witness after witness, talking about what a trollop she was and how she shouldn't be she shouldn't be queen. And we had Sir Henry Brougham, whose job it was to defend her, and he was told, "Look, you got to be careful. You've got to, you can't defend her too hard because it'll undermine the monarchy, and the king won't like you, and other royals won't like you, and so you better be careful." I bring this up because this happens. This is a part of the dilemma for parents' attorneys. This system is rich with people who are powerful and powerful over clients. The court, the social worker for sure, most importantly, and child advocates. And so we've struggled working with the attorneys feeling constrained about what they can do, because if they defend their client too hard, there may be retaliation against their client, against them. I have seen that. That sounds improbable, but I have seen it. And so
other clients.
And against their other clients, absolutely. Yeah. So Sir Henry was pretty clear about it, right? That it's just his client. That is who he has loyalty to. And he must not regard the alarm, the torments, the destruction which he may bring upon others. He has to do his job. He has to represent his client. That is a fundamental moral value of public defense. You saw that in all the other memes too. But I just wanted to bring that up because it is a tension within the system, and it's a tension that parents' attorneys feel. Yeah, it's actually kind of rough sometimes. I think sometimes you can feel a little lonely for your client because of it. Oh, interesting.
Yeah.
Something we need to grapple with. Yeah. About the kids. I'm going to say something about my representation. This may or may not be true of other parents' attorneys, but I was quite clear with my clients at the get-go that one, they needed to understand that their rights have not been terminated. Sometimes parents don't understand that. And one of the things that you still retain is the ability to have an opinion about the best interest of your child and to fight for what is in your opinion is the best interest of your child, even if it conflicts with what other people feel is in the best interest of your child. So what I would tell my client is I'd say, you tell me what's in the best interest, what you think is in the best interest of your child. As long as that's the position we're coming from, I can be with you the whole way. We're gonna be able to go the whole way. I will have your back the whole way. And I don't know if that was similar for you, Jacob, but that was definitely my approach.
Absolutely. Absolutely. And I mean, I always struggled with in criminal public defense, you know, it really was up to the state to prove it. And criminal defense attorneys have, you know, tools with which they can push back. But I often felt like for us, once the kid was out, it became the burden shift, right? So the burden wasn't just, you know, us holding the state responsible for their awesome duties, but that the parents had to then prove that they were capable and able to parent, that's a hard thing to try to prove when your kid's not with you.
Yeah. Okay. Back to the chat box. If you had to hire a lawyer, what qualities would you look for? I don't mean necessarily for a parent's, like that you needed a lawyer in a child welfare case, just had to hire a lawyer for anything in your life.
Experience, yep. Honesty.
Mm-hmm. I saw tenacious up there too, good communication skills. Yep.
Somebody say something about honest. What does that mean to you? What would the quality of honesty in your attorney look like in their representation of you? Shark instinct. Right, so honesty has come up how many times now? 4 or 5 times?
Yeah. Tell the truth. Accessible, good. Yeah, so I don't see a single one on there that is inconsistent with what we look for. With the exception of the shark one, I'm not sure what the person said about a shark. If you just mean
someone who's going to fight like the devil, who's going to turn over every rock, stone, brick to make it happen for me. That's what I mean. Someone who's not going to go in there and be soft and fluffy.
Yep.
Perfect. We like sharks. That's a part of it. I think we like sharks in the adversarial space. I have to think about that. Yeah. Yeah. Good. All right. Similar beliefs, culture, respectful. I'm glad you said culture. I mean, I think the older term is culture competence, but maybe to the extent that that's still right. Cultural humility is actually maybe the better term, or is the better term, but yeah. Okay. So kind of the whole reason for that exercise is just to show that we have a lot in common with what we would want. Like that's how we want parents' attorneys to be, and that's how you too would want an attorney who was representing you. and the honest part, I think we can address. Oh, no, I don't have that in the RPC's section. So maybe I'll just say something about it. Remind me, Jacob. I'll catch.
I will.
I'll catch that part because I think it's tied into one that I will be talking about. So, okay. So my premise is that law school, I say train lawyers, but really it breaks lawyers. And what I mean by that is that people going into law school have the same mental health and chemical dependency makeup as the rest of the population, right? The same percentages of people who have mental health problems or chemical dependency problems. Totally the same. We are totally fine before we go to law school.
There's actually some studies that say that we're actually better off.
Oh, interesting. Okay.
Than the other populations.
Well, the next part of it is about 6 months into law school is when the break happens. And I'm not sure, I tried to look, it's been a while, but I tried to look at why. And I'm not sure that they necessarily know why it happens, just that it does happen. That mental health and chemical dependency problems are greater for lawyers that early, right? It doesn't wait till they're lawyers. It happens right there in law school. And so I did do a little bit of digging on kind of what law school is trying to do and how it trains students on how to think like lawyers. And you can kind of see the different pieces to that. But the bottom line is it means that coming out of law school, we theoretically know how to hold others accountable for following the law or protecting clients when they're accused of not following the law. We do that really well. That's what our job. And you can see how all of that would fit nicely into all of the public defense identity things that we've already talked about, right? That you're really good at this defending and justice, and all these things are in some respects kind of aggressive. It's all a part of that adversarial system, and so that's what lawyers are trained to do. You know, we are not trained to do the other half of it, which is maybe the most important half in the child welfare system, right? So it's a collaborative system and an adversarial system. I spent way too much time talking about the adversarial system. Maybe not too much, because I do want you to come away with that notion of this is how we think, this is what we're good at. Now, some parents' attorneys are excellent at the collaborative side of things. I would venture to guess most, or maybe more than most. But some of them are stronger at the adversarial piece. And a little bit of the adversarial bleeds into the collaborative, right? If you're at an FTDM meeting, if anytime that the group is getting together to try to solve some problems, some of that adversarial stuff is going to bleed into that. But all is not lost. We actually do pretty well, right? Most cases are settled, right? Most times we're able to come up with solutions to things. These cases are not tried in court as the main way that we resolve our problems or issues. So does anyone know who these crazy kids are? Put it in the chat if you know who these people are. All right. Well, there you go. There's the answer. Justices Scalia and Ginsburg. And they're famous for being on total opposite ends of the spectrum in their legal thought and philosophy. And they've had lots and lots of arguments about it all the time. And even, especially Justice Scalia, he can be pretty combative. Very combative, actually. But yeah, they holidayed together and they went to the well, they were in an opera together. Yeah, right, they had it figured out. Yeah, that's a great point, Nancy. There was a deep respect in their relationship, 100%. And that's a part of what we need to be able to do when we're operating in that collaborative and adversarial space. One thing I think is pretty interesting, right? Social workers operate in a pretty collaborative, their ethics are designed around social work and collaboration. And so it's a little bit harder for them to go into the adversarial space. Now, but attorneys, shoot, I don't know, I think of a bunch of times that I've had arguments, like big arguments in court, where the prosecutor and I were just really going at it. And then you go step out in the hallway as if nothing happened, right? That's a part of being trained, but and how law school kind of breaks you. That ability to be able to put that stuff aside. And some of it, like Nancy says, just respect, right? Even if it was someone that a prosecutor that I didn't know super well, we both went to law school. We both knew what we had gone through. We both knew how we were trained. So, you know, whatever they said about me didn't really make a difference. So, yeah. I kind of like this one. Notice how she's smiling. I think that's kind of a bit of how we need to think of our disagreements and be able to do that, right? Obviously, that's a kind of a biting one, but there's I put it up there to be mischievous, but then I started looking at it some more, and I see more value in it than me trying to make fun. So, okay.
Brett, there's Tamara has her hand up.
Yeah.
I remember when I first started doing this 20 years ago, I guess it is now. The first funny thing I learned was I walked into court and the attorneys were both just going at it. They were both right and they were going to both prove they were right. But when the judge and all the parents walked out of the room, they all just started laughing and cracking up. And I'm sitting here staring at them like, what the hell? Dad, we're just fighting 2 minutes ago and now you're going out to lunch together. So that was my biggest learning curve on attorneys, was don't believe what you see.
Well, and then can I ask you, have you been on the other end of an attorney, kind of going, I don't know, going after you a bit?
Yeah, particularly in trials.
And how was that for you?
I didn't like it.
Yeah.
And I had one that just kind of asked me, what was the last day of your visit? And I said, November 19th. And she goes, well, how do you know that? I said, because that's my anniversary. I was going out to dinner. Oh, okay, thank you. And that was it. A couple here in Kitsap County that are just bulldogs, and you just hope you don't go to trial with them.
Do you find that you're able to put that aside now? Like, it sounds like you've been doing this for a while, and yep, they might go after you, but you can still work with them on the case or other cases.
Oh yeah, I've learned to just not take it personally, that they're just doing their job and they go home at the end of the day just like I do.
Yeah.
And I learn from what they go after me for.
It's like Wiley the dog and Sam, or Wiley Coyote and Sam the dog. I think I remember that cartoon, but go at it and then they hit they punch out their time cards at the end.
With their little lunch boxes. Yeah. Yeah.
Yeah.
Excellent.
Okay. Let's take a little poll here. Make sure.
I can launch it if you want.
Oh, I got it.
Okay.
You guys see that? There we go. No, not necessarily constitutional power, but like who's going to be the most at the end of the day, oh, I'm gonna hate that expression. At the end of the day, whose will is going to be done? Okay. Yeah, 75% said the judge, and I appreciate that. And then child advocate is the next most powerful. Last time we did this poll, it came out a bit different than that, if I remember correctly.
Yeah.
That it was the DCYF social worker. Jacob, how do you think this poll would come out if it was parent attorneys doing it?
Oh, yeah, sure. I would probably say that parents' attorneys would say social workers and child advocates. And maybe to a certain extent now, well, it's just, it's always interesting to me that whoever you're asking is pointing to other people in the room.
Yeah.
But I think frequently parents' attorneys feel like they are the, well, they're the last thing standing between their clients and the destruction of a family, and that frequently they're the only thing standing in between, clinging to the side of the cliff. But that you know, the folks in the room who are being asked for their opinions, and those opinions being given substantial weight, whether that's because you're a CASA and you are brought in to give your opinion, or you are a social worker and you are brought in to give your expert opinion. Or you're the AG and you have a professional client.
Did I leave AG out for this one?
Oh, no, I didn't get any votes. It's at the bottom.
Oh, I didn't scroll down. Okay.
It's definitely there.
I am super curious, for those that said child advocate, what's the, why that is. I know why I would think that is, but I'm curious since this is your space. Oh, there we go. Oh.
Can I just verbally answer that one? I'm having a hard time typing.
Absolutely. Absolutely.
So I'm on my little iPad because my dogs are going to go crazy in a few minutes here, but I didn't scroll down. As soon as I saw the question, I said, well, it's the judge, and I didn't see the judge.
Gotcha.
So I didn't see the judge or the AG at all. So, and I'm having, you know, I wish I would have seen the judge. So thanks, guys.
Judges don't pick sides. The child advocate doesn't pick sides.
Yeah, they're often the tiebreaker. My experience has been.
Yeah. The goal is supposed to be best for the child. I'm not sure that I agree that it's necessarily best for the child. I don't think that's how our laws are structured. It might be bad. It might be how your advocacy is structured, which makes sense, right? Best interest of the child. But yeah, I gotcha. Okay, I'm gonna end that one. This time we'll need to scroll down, make sure we scroll down. We're gonna move, that was inside the courtroom on the adversarial side of things. Then we're gonna come outside the courtroom in the collaborative space. And then, yeah, there we are. Who has the most power?
There's 8 options. The AAG or the Assistant Attorney General is the last one.
Yeah. I definitely think we would agree that it's the DCYF social worker
Yeah.
in our mind. But I still think that parents' attorneys would put themselves and then parents at the bottom. Got a message here. Social workers seem to make executive decisions without consulting anyone. Yeah.
Yeah, it's also an amazing amount of power to have about where you're putting, where the social worker is putting their energy. Are they making that referral right away? Are they waiting? Did they make that ICPC request right away? Did they submit, you know, there's just a lot of moving parts that can get delayed or subverted or pushed through immediately.
Yeah, can someone who said parents attorney chime in on that?
Yep, that was me again.
Did you pick parents attorney for a particular reason?
Well, I think that their power really would come from speaking to their clients and trying to sometimes bully their way to get what they want. I have that going on right now with an attorney, and we're at definitely opposite ends of it, but we haven't had a chance to talk it out yet. And but just, I think sometimes because they get those little meetings outside with the parents and their recommendations, and they don't really have to agree with what any of us want to do. I think that gives them a lot of power.
Does anybody else in the group have a response to that? Sorry, go ahead, Tamara, or whoever was talking.
No, I was just turning my mute off.
Yeah, well, I think a part of the point of this is that you have to operate differently in the two spaces, right? What an attorney would do to persuade a judge is very different than what they would do to try to persuade a social worker. And I suppose I'd acknowledge some power imbalance in that a little bit. A power imbalance from the social worker, just the amount of power that they actually have over this family, but also power from the imbalance on the parents' attorney side, just by virtue of a perceived status that they are an attorney, which I think sometimes social workers find pretty intimidating. But we definitely have to operate in these two different spaces in different ways. Julie, I think you're referring to the parent attorney, that you've got a parent attorney with a really strong personality and seems to have the control.
Yes.
Yeah, you don't have to name names or anything, but just can you say a little bit more about that? Are you in a big county or a small county?
No, a small county. And, you know, we have several attorneys who, because we're in such a small county, we share with a few other, like we're in Whitman County. And so we share with Spokane County and Asotin County, Lincoln County, so a lot of the outlying counties. But this particular one that's pretty strong is less spread out, I guess you say, but just she's just I hate to say, a much stronger advocate, and just goes gangbusters, which is a good thing. But she's also she's just 100%, where some others may be a little more what's the word I want to say? Yeah, they're busy, or they're spreading in many different directions. And I don't want to say too much to sound terrific probably on those others.
Yeah. No, I think I understand. Yeah. And it sounds like you're okay. Sounds like you may be okay with how they're operating in your county.
I know this, but it depends. It really depends, honestly, on the issue at hand. I think, you just get strong, you get personalities together, and sometimes the strongest is going to win, and the others are just kind of like, they don't have the energy, or it's not something they don't want to die on that hill, I guess you'd say. It's kind of how I can feel about it. I can't say that's just my perspective.
Interesting. Yeah, no, I appreciate that. Thank you.
And two examples I've had recently of where the parent's attorney had what seemed to me like negative or a power for a negative outcome in a case. The first one was where a father who really wasn't involved with his child didn't show any interest in him. And the parent's attorney just refused to even talk to him about relinquishment. Mom had already agreed to relinquishment. It really was not a good thing for this child. It took us another 6 months to terminate the rights. And the second case was we were transitioning a child home, and the foster parent and the mother had been getting along really well, and the child's attorney got it into her mind that the foster parent didn't want the child to go home. And so when we were talking about a more lengthy transition period, she just really fought it, and I think harmed that relationship with the mother. So those were two unfortunate situations where I think the attorney did have power over the parent and consequently over what happened in the case, and it wasn't really, in my opinion, used appropriately.
Okay, that's a good thing. I'm going to put a pin in that, because I'm going to come to some of the rules of professional conduct and might answer your question, Mike. Okay, got one more poll question here. So start to finish, DCYF follows the law and their policies in every child welfare case. Okay. There'll be some more coming in here, but I think we've got pretty overwhelming sometimes and almost always. This wasn't a hard question, but my purpose in asking it is the spaces where DCYF isn't following their law and their policies. And if you go back to Sir Brome and all other stuff you saw with public defense, those are the spaces that parents' attorneys have the obligation to defend their client about. And one thing, for a while we were doing civility trainings. I don't think we've really been calling them that as much anymore. And I was all in on the civility trainings because, and I think Jacob too. Jacob and I were, in our practice, we're very collaborative attorneys. We had our moments when we would be on the adversarial, but we both understood how important it was to have really good relationships and work those cases in the collaborative spaces. And so after doing the civility trainings a number of times and wanting to hear when there were problems, most of the time when most of the complaints to me about our civility issues had at the root the social worker not getting their case plans in on time or not making referrals in time. And the more I would dig into those, it became really apparent that the social workers felt like they weren't intentionally not doing what's required of them by statute policy. They just couldn't. Or at least felt like they couldn't. And so they were being taken to task by attorneys who had an obligation to raise the issue and then sometimes even asking for contempt. And putting myself into the shoes of the social worker, I'd be pretty peeved about that. I'm being held to account for something that I really don't have any control over. And so my perception is that attorney is being uncivil to me. And it came up over and over again in a number of counties. And I started feeling uncomfortable about the word civil. Because if that's where we were, if that was the thing that was uncivil, wasn't there also another part of this? That by not complying with the statute, by not complying with policy, the social worker was being uncivil. Not intentionally, but as the agent of the state. And the state of Washington was acting upon this parent, this family, in a way that they certainly didn't expect of the parent, right? If the parent didn't follow the court orders, they were going to be held accountable for it. And the parent sits there and the parent's attorney sees no one's holding the social worker accountable for not doing what they're required to do. And so I got really, really uncomfortable with civil because what was happening with it was being used to punish parents' attorneys for doing the job, or to go after or intimidate parents' attorneys for doing the job. So that wasn't the purpose of all that. That's what we weren't trying to do. And so that's why this particular presentation has evolved a lot into letting people know, emphasize the role of a parent's attorney, that they have a duty to point out when the department isn't doing what it's supposed to do. The social worker, without regard for that poor social worker who, I would agree with that social worker. They're being abused by their bosses by not having the capacity to do the work. And so that's kind of where I've been trying to go with this, and to really think about what it is we do. I can remember feeling pressure. Why are we having a hearing today? We all know this is a stupid issue. We all know that the parent is going to lose. Why are we having this hearing?
Why are you wasting this court's time?
Exactly, and huge social pressure. You're upsetting the judge. All the players that are in the courtroom should be out doing other things. And I remember one time in particular, I had a client who had just done so well and was getting her kiddo back pretty early. I'm trying to remember if it was like about 6 months or 9 months, but for our court, it was early. And the proposal from the state was, yeah, we're going to transition your child home to you, and we'll do it over 30 days. And that was standard. Our court always did a 30-day transition. So it's like, great, we agree. My client says, no, we don't. Like, wait, this is what the judge is going to do. And she said, well, they didn't transition the kid out of my home. So why do we need to have transition now? And so we had the hearing, and everybody was pissed that we had the hearing. And the judge said, yeah, return home, congratulations, we're going to transition over 30 days. And my client kind of stormed out of the courtroom, and I was a little worried, and I followed her out, and she turned around and she gave me the biggest hug. I was like, what? What's going on? She said, thank you. I feel like I got heard. Right? So there was value in me upsetting everybody else. And that was one way. I was pretty young, a young attorney at that point. And I learned that, the value of having the red-faced hearing, right? The hearing that you're kind of embarrassed, the argument you're kind of embarrassed to make because you know that it's either not going to win or isn't a great argument. But it's really important for a client to be able to do that, to be able to be heard. I mean, I think we definitely saw that in some of the memes about public defense values. So I just kind kind of wanted to share that piece with you. Do you, before I move into the RPCs, Jacob, do you have something to add?
Oh, no, I think the only thing that I would add is there's some comments in the chat about social workers, being the fall guy for the system, and also being part of the delay. And I think ultimately what all of those delays, lack of services, lack of funding, I think ultimately who loses are kids and families. And it may be in the heat of the moment, the social worker has a bad day because the court says, yes, I'm going to continue this because your court report is late, because you're overworked and underpaid and understaffed. But very rarely is that taken into consideration at the time of filing of termination. So, yep.
Yeah.
I mean, and honestly, those arguments by the parent's attorney ought not just to be, this continuance is the department's responsibility and the social worker needs to get the court report on time. But maybe there's an argument to be made that there's a good cause for not filing termination if our system is so underfunded and so backed up and so lacking in services for families to try to reunify.
One more practice tip story around this, that when you're going to have one of those days, this is Amelia Watson, who's also another one of our managers, and she used to be in Pierce County. And one of her practice tips is when you know that it's going to be, that you're going to have to cross-examine a social worker or a child advocate, and it's going to be hard because just the facts require the attorney is going to have to be pretty aggressive. Right, she would go up to the social worker and just say, "Look, I just want you to know ahead of time that today is going to be rough. We're not going to have any fun today. Tomorrow we can have coffee together. It'll be fine. But I'm going to have to ask you some tough questions." And I super appreciated hearing her tell that story when the first time I heard it. It was just that, right, there's a way that you can do this that brings a little bit more of the collaborative side into the adversarial side. Okay. So how are we doing? Ooh, we're doing good. Okay. So let's talk about the rules of professional conduct, something that governs all lawyers' behavior. Yeah, we get tested. This is one of the things that we get tested on coming out of law school. According to the RPCs, there's 3 ways that we're a representative of the client: as an advisor, as an advocate, and as a negotiator. And the advisor piece is some of the stuff that you're probably not going to see too much of. The conversations that you're having with the client behind closed doors. The best interest conversation that I told you that I would have with my clients, that would be one that you would know about and shouldn't know about. But that's how you end up advising your client about their rights and response and obligations. So the advocate piece, if you remember, I talked about someone being a zealot, that public defenders are required to be zealots. And even though I disagreed with that, that comes from a lot of states. Rules of professional conduct say zealous advocacy. Our state says conscientiously and ardently asserts the client's positions. And that takes place, it says here, under the adversary system, but it's also takes place in our collaborative system, in the child welfare system, right? There's times in FTDM that the attorney is advocating for things. And hopefully they're doing it both conscientiously and ardently. And then, of course, as a negotiator, that's the stuff that's happening in our collaborative spaces. But one of the words that came up when you guys were listing attributes of attorneys, notice pop up here: honest dealings with others, right? So that's the general principle. Let's get to some more specifics here. Go on and click. It is a client-directed representation, which means that that the client says what the objectives of the representation are, and then the attorney has to do that. So this is one space, Mary, where you were talking about the attorney and relinquishment. It's quite possible that the client wasn't interested in relinquishing, that they had that conversation, that he understood that. He can't really tell you about that. And so if his client doesn't want a relinquishment, he has to abide by that. Same with the confidentiality. Now, it's possible in the story, as you were relaying it, Mary, that the attorney told you that he had not talked to his client about a relinquishment. But assuming that did not happen, right, you wouldn't know. That's part of the confidentiality piece. The render candidate advice, that's our RPC 2.1. This one is you can advise your client about the law, but you can also advise your client about other things. And they could be case specific, or they don't have to be case specific. Right, they can be moral, economic, social, or political in nature. And that's the way it's entitled is counselor at law in that RPC. You're being a counselor at law. And I know I've had plenty of those conversations with clients, and I'm guessing you did too, Jacob. I'm sure you did.
Many. Many. Before every hearing, before every meeting, before we responded.
Yeah. Yep, absolutely. And then clients with diminished capacity, you can think about clients who maybe have a traumatic brain injury or developmentally delayed. And technically might be, it might be a youth that you're representing as a parent. That definitely happens. So the whole idea is that you have to continue to represent that person to make it as normal of a representation as possible. Sometimes that puts attorneys in some tough spots, because another thing that they can't do is assert that their client, except in rare instances, can't assert that their client has a diminished capacity. That would make it problematic for them to parent, unless it's something that they could figure out there's a remedy for, and that they could accomplish the remedy. So, yeah. And then advocacy. We talked about what it means to be an advocate in the child welfare arena. Right? It's every stage of the proceeding. You are checking in about services. You're checking in about visitation, and particularly with House Bill 1194, there's even more opportunities to do that and more requirements to do that in terms of visits. So may have noticed increased activity with the parents' attorneys around that, around making sure that we're starting with the presumption of unsupervised visits, and that we're revisiting that at each spot.
Some of the things that I think might be added to this at this point also is development of safety plans. I think a lot of you are doing the safety assessment training, safety planning training. Parents attorneys are doing that too, and so advocating for not just what the case plan is or what services should be in place, but arguing to get a safety plan in place so that the child can go home. And also, if that's not what's going to happen, placement. So placement with the preferred placement that the parent has, whether it's a relative or a suitable other, And sometimes it's arguing against a placement if the maternal grandmother is not someone that the parent feels safe or comfortable with, or that is going to be supportive of reunification. You might have an attorney advocating against a placement. But all of those things are things that attorneys are, likely you're seeing them advocate for strongly.
Yeah.
And you may not see the attorney at the shelter care hearing saying, yeah, give my client services. We're definitely going to agree. Because unless there's an agreement by the parent, the court can't order the client to do services. But again, like Brett said, in terms of being a counselor at law, you're walking out of that courtroom and saying, okay, the straightest point from here to getting your kid back is you getting on this pathway and dealing with whatever parenting deficits exist. And sometimes it's a conversation about what are those parenting deficits and having a really honest conversation about what that is. And you are not likely to hear an attorney say, well, I now know all my clients' deficits, so we're going to disclose all those to you and tell you what we're going to do about it. But just know that those are conversations that are happening.
Okay. Well, we are moving into the game portion of so Jacob,
Do you want to check in before we hit this and see if there's any questions or any clarification anyone needs before you get to answer some questions?
There we go. That's right. We were going to do that. Yeah.
Anything anybody is confused about or wants to talk about in terms of what you've heard?
Yeah, Jacob and Brett, this is Tim. And
Tim.
I was wondering, we have a lot of parents and we want, with the visits and so forth, and how can volunteers and guardian ad litems really kind of promote the idea that visits and services, I mean, there's a lot of barriers regarding being able to attend applicable services that will help the parents. And then the parents are visiting and constantly trying, are focusing on the visits and their kids, and we want them to be with their parents, and how are we figuring out how to reunify them? But over a period of time, a lot of times there's not a lot of progress or measurable progress regarding the services that have been ordered. And I'm just wondering if you could help us, like, how can we as advocates help that without intruding and being what do you call it, not strength-based? I mean, how can we be strength-based in that process when we talk to parents? I don't know. Does that make sense in what I'm saying?
Yeah, can I say back what I think I heard you say?
Okay, thank you.
Yeah. So it sounds like what you're saying is that the parents that you have are very focused on visits and being at visits, being with their kids, and that's happening. And at the same time, what you're saying is the time lapsing in the case and progress not being made towards remedying the safety threats. And then how do you engage with a parent about that?
Yeah, that's correct. Thank you. And
Yep.
Usually it's just, please talk to your attorney, and we really want to try to bridge that. Hey, this is my role. I really want reunification. This is going to be very difficult. How do we try to explain that?
Right. Well, I think, Tim, I think some of it, if we all start using, and I'm sorry, I'm going to sound like a proselytizer about the safety assessments and safety framework. I think if we are actually using that tool and parents know really early on at least what the system thinks the safety threats are, and that it's not doing a service, going to a class, doing this thing doesn't necessarily equal that threat is gone. But if a parent knows what the threat is, so the threat is not that you're using drugs, the threat is that you are using drugs And when you use drugs, you are not present and capable of keeping your 2-year-old safe. Right. And so, so the focus is really on helping that parent understand what do they need to develop in themselves in order to safely parent that child. So that you're coming back around to that. Now, that being said, I think we do a poor job as a system of pointing out where our parents' strengths are. And I think we're very facile with criticism and not so great with that, the strengths-based approach, but also really being able to point out, the fact that you are surviving on $20 a month and getting to your visits on time and do like all of these things that show that you have strengths. And so being strengths-based, but also being able to clearly articulate from the very beginning what it is that the parent needs to develop in themselves in order to get their kids back, so that you can be checking back in on that and saying like, look, here's what I saw you do today. What I saw you do today was you showed up and you weren't high, but you were also able to change your kid's diaper or take them to the bathroom or do X, Y, and Z. And here's the gap. The gap is we need you to be able to do that, not just for the first 15 minutes of the visit, but for the entire 2 hours. And once that happens, we can start to expand into these other areas. But I think we need buy-in from the whole system. We need buy-in from the social workers to be able to also articulate those safety threats and not just, we have concerns. And then the other thing I would say is, if to the extent that you can bring the parent's attorney in as part of that conversation, so that, the client is hearing it, not just from you, but also from their attorney.
Okay, I appreciate that. I mean, group emails, group texts, those work really good a lot of times.
Yep. Yeah, I mean, I know that we're kind of getting away from this, but when, up until fairly recently, FTDMs and shared planning meetings all started with, and how did we get here? And going all the way back through the history of what happened. I would love to see that shift through to, what have we seen the parent accomplish? What have we, where are we seeing development in parenting capacities and protective capacities, and where do we still have to go? Nancy, you have your hand up.
Yeah, on the slide where you set forth the roles of the parent's attorney, one of them, I think it was, advocacy. Anyway, it said that the attorney really needs to take guidance from the client, that you are in a sense following your client's instructions. And I think an attorney must abide by a client's decisions concerning the objectives of representation. So what happens in situations where, I know I've had, a conversation with a parent's attorney where, I say, I had an idea that might be really helpful to this parent, and the attorney says, well, the parent is not communicating with me, so I have no authority. And the attorney kept saying, I have no authority, which I took to mean that the parent has not provided, information about their wishes and decisions. They're just not communicating. Then what do you do?
What do you do, or what does the parent's attorney do?
What does the attorney do? I mean,
right?
How is the case supposed to move forward when it's hard for the parents' attorneys to communicate with the parents and get a clear sense of what they want?
Yeah, I'm happy to answer that, but Brett, I just took a bunch of the floor, so you go right ahead if you like.
What I was going to say about that was that in a situation like that, the attorney at some point is going to make the decision, or may make the decision to withdraw, because they don't know, if they don't know what their client wants in the case, they can't advocate for it. And so it's pretty, so that is pretty clear. So our contractors are are just that. They're independent contractors, and their bar card is their bar card. So I'm not going to say that that particular person's wrong. They have their own analysis. But in my analysis of the rules of professional conduct, you should not have known that they are not in contact with their client. But I also recognize that that's really hard. I also recognize when I had cases, it's really hard when there's someone sitting across from you, be it a judge or somebody else that you like and care about, and they want to talk to you about your client, and you don't want to feel you try to ease the awkwardness by saying, well, I'm not really in touch with them. But technically, you should not know that. But
yeah, and I might have been paraphrasing. I mean, sometimes let's say, have you heard from the parent, and the attorney will say, I can't answer that question.
Yeah.
But then the attorney will also say, I have no authority. And it's sort of because I'm in on the situation, I know that there are really, I might know that there are communication issues, but okay, I know we have to go on, but how often does an attorney withdraw? How often does that happen?
All the time. Yeah, it happens frequently, and attorneys make decisions depending on where they are in the case and what they think is likely going to be helpful or harmful to the client. So, at some point, a client may say, I actually had a client call me and say, I joined the circus, I'm not going to get my kid back, but I don't want my kid to go to the maternal grandmother. And I was like, all right, so you get to set the objective. And the objective is that you're not going to do what you need to do to get your kid back, but you definitely don't think it's safe for your kid to go here. So I had the opportunity to represent my client's wishes up until the point in which I felt like it had been so long that I hadn't heard from him and I wasn't able to reach him that I could no longer ascertain what his wishes were. And maybe at that point in which, the kid doesn't go to grandma or grandma's ruled out, and now I have no idea what he would advocate, what he would want. And then I have to take steps to withdraw. But in my withdrawal, I have to try not to hurt him too, right? So I can't withdraw and leave him in a worse position. And it's very case specific, but lots of attorneys also don't want to go to an empty chair trial because that's hard. And so if you're going to not go to an empty chair trial, you have to withdraw early on enough so that you're not doing it on the eve of trial and leaving somebody high and dry without an attorney and getting out just to save your own skin versus, taking a step in order to, generally it's not protective of your client, but sometimes it is. Sometimes you don't know where your client is, and you being there representing them when they are, say, in a coma in a hospital and you can't find them is actually less protective of them because they're there being represented, and it's more likely that the final decision in that case will stand because they had representation versus, they weren't here, they weren't represented, they were in a coma in the hospital, they should have an actual trial. So it's hard to say, but attorneys frequently withdraw. Per our contracts, they can stay on a case, but they may not get credit for it depending on how long it's been. So
you might also have withdrawals. This happens all the time when there's a breakdown in the attorney-client relationship.
Sure. Yeah.
Which is also a challenge for the attorney because they may have lots of information about how bad of a person their client is, but can't really disclose it because it puts their client in a worse position. Unless, of course, the client wants them to illustrate the breakdown of the attorney-client relationship. Right. But those are always really sticky.
Yes. And the only other thing I wanted to say about the client-directed representation. So a client can say, look, I want my kid back, and here's what I want you to do about that. So they set the goal, but they don't necessarily set the strategy. So if you agree on the strategy, like here's how we're going to get to your goal, great. If the strategy of the client is I'm going to threaten everyone on the planet in order for them to give me back my kid, you as the attorney get to say, yeah, that's not the strategy that I'm going to implore. I will continue to work on getting your child back to you, but I'm going to initiate a different strategy. And that's sometimes where the breakdown in relationships happen.
What other questions do you have? We definitely wanted to create enough space for you to ask. I mean, it can be about the adversarial and collaborative spaces, but it can also just be why does it, like that's one of our old titles. Why does the parent's attorney do that?
I have a question that's easy. What what do we do when we see one of the parents? How do we make a complaint against a parent's attorney?
Just contact OPD. That's the easiest.
Yeah. And there's, I mean, our job as contract managers is to make determinations about who is going to be representing parents in the state. And because we have contracts all over throughout the entire state. And we may say to you, like, I can take action on the contract, but you may want to think about contacting the Bar Association. If, you know, so those two routes that I would say.
And the hard part is that you may not know what action to take. Like, so it's some of it might just be good information for us to have about that particular contractor, and other people have complained about that contractor, and we see it's an issue, so we'll discontinue contracting with them. But you would never know that we did that as a result of their complaint.
The other thing that I would say is we take when clients call and complain about their attorneys very seriously. I mean, and we definitely do a follow-up investigation. So if a client calls and says, I haven't heard from my attorney's not calling me back, we may ask some questions like, well, when was the last time you called them? Well, this afternoon. Okay. Did you leave a phone number? That kind of thing. But, you know, if you are hearing from clients who are complaining about their attorneys, you can call, but it also, you know, it matters a lot when the client calls.
Yeah.
When I get parents that complain about their attorneys, which unfortunately is frequently, what I tell them to always do from the beginning is to have a notebook by them. And every time they call their attorney or their social worker or the CASA, whomever, write down date, time, and what you were asking them about.
Yeah.
I said that way, if you go into court and you tell the judge, well, I've called my attorney like 100 times and they've never called me back, he's going to laugh you out of court. But if you walk in there with your notebook and say, well, I've called my attorney on this, and this date, and I left this voice message, and they never respond to me, I said, then you're going to get some action.
Yep.
But
Yeah.
you've got to have the proof, not just the, you know, well, a whole lot of times. And that's for everybody. That's not just the attorneys, but that's the best way I can think of as a civilian to kind of give them some power to do something with it.
It's good advice for sure.
Yeah, did you do that with your clients, Jacob? I did this. I did.
Oh, yes. Yes. Yeah. And if they had a phone call with a social worker, I would say follow up with an email. Yep.
What other questions do you have?
Or comments? You think we're ready?
Ready.
All
Okay.
right.
It'll take me a second here. Sorry.
No problem.
There we go. Nope. I went back. I forgot.
Oh, too far.
Okay, one more. There we go.
All right, so this is questions for you guys, and just go ahead and put your answer in the chat. But rude or doing their job. So I'm going to read it to you. The parent is asking that the child be transitioned home. CASA, or the guardian ad litem, gives an oral report to the court at a review hearing. The CASA, or child advocate, did not get a chance to see the child prior to the hearing because the child is placed out of county and not much has happened. She did talk to the foster parent on the phone who said the child was doing fine. Child advocate's opinion is that the child should not be transitioned home at this time because she's worried about the parent's stability. The parent's attorney spends a great deal of time arguing that the child advocate has done a terrible job investigating the case and tells the judge that the child advocate is incompetent. So go ahead and put in your chat, rude or just doing their job.
referring to the parent's attorney, just to clarify.
You're right. Yes, not the advocate. Both. Yep. Rude. But just doing their job, but rude. Both. Okay, so anybody want to talk about why they think it was rude? Okay, I don't see anybody. Anybody want to talk about?
I'll say
okay.
something, Jacob.
Great, go for it. Go for it.
My first thought was, yeah, I think, they're doing their job, but it says the attorney spends a great deal of time arguing that the CASA has done a terrible job. And my thought on that would be the parent's attorney should be spending time on what his client's been doing, or her or him, what the client's been doing as to why the kids should return. I would say spend more time on that, and then if they want, they can say what they need to say regarding the CASA. But and that the attorney may be right, but at the same time, I would, if nothing's really changed in the case regarding the child, then what has changed for the attorney's client?
Just so you know, there's no right or wrong answer. To
Right.
so,
But I'm just telling you what.
Yeah, no, I'm just saying I'm not going to tell you, you're right, you got it, or you're wrong, you didn't get it.
I don't expect that.
Does anybody have an alternate opinion or want to have a conversation about what Tim said? Nancy, you're unmuted.
I feel as if the attorney is deflecting from the real issue by refocusing on something that really doesn't apply here, like this parent stability. He's just trying to divert attention from his client.
I agree with Susan.
Yeah.
and it's focusing attention. It's spending time maligning the child advocate instead of addressing the question of the parent stability. And it seems like the appropriate thing, if the attorney wants to press on anything, is tell me more about the parent stability and what's your evidence. I mean, aren't you supposed to talk about evidence, in the courtroom? What's your evidence, for the parent's lack of stability? What have you found? And certainly to judge the child advocate on the one sort of data point of not seeing the child prior to the hearing because the child's out of county and not looking at anything else. Anyway, it just doesn't make sense.
Anybody else?
Yeah, that seemed kind of weird to me. If nothing has happened in the case, that probably means that there's been no services or anything. So how have we built stability at all? Isn't that the whole point? The children were removed because of stability issues. If nothing's happening in the case, then stability hasn't been established yet. So why are we even talking about putting the kid back or changing anything? We need to be working on getting the parents stable.
Yeah.
Okay. Anybody else? Thoughts, feelings?
I got a question. It seems like the focus has been on not the words used in the argument, but just the amount of time spent on the argument. So I'm curious if people are okay with the word incompetent. Is it okay? Let's take the great deal of time part out of it just for a moment, and just that, is it okay for an attorney to argue that a child advocate was incompetent in their investigation?
I would say that the attorney's going for shock value. Also, well, since I've never been called incompetent, I might probably be pretty upset, but I would also suck it up, because just because one person is being a little incendiary doesn't mean that I'm going to be incendiary. I'm going to throw cold water on that. If I'm incompetent, I'm going to go like a Roman candle, but I'm not. I come from everything. I do due diligence on everything. So if I'm incompetent, the load of paper that I probably dropped on him didn't get read.
So
to me,
Adrian
that's-
has a, oh, sorry, Gabriel, go ahead.
Go ahead.
I was gonna say, Adrian just put in the chat a couple of comments. So one of the questions is, did the CASA talk to the parents and the parents' attorney and the social worker? And then Betty says, can the CASA cite evidence of lack of stability for the parents and the parents that the parents' attorney can either debate or acknowledge? Right. The only investigation was a phone call to the foster parents. So I'm just going to say one thing that I think is meaningful to me, and that in most other court cases, I don't know any other case where this happens, but like throughout all different areas of law, never is there a layperson, and I apologize for calling you that if you think that is not a kind thing to say, but a layperson asked for their personal opinion. Most child advocates, and I think some do, but most child advocates don't come to the table with some sort of a degree or expertise that provides them with the qualifications of an expert. You're a layperson who is coming to the table to tell the court what your personal opinion is. So if you have an expert on the stand who is giving an opinion, you as the attorney bring a challenge to how much information they had, what they looked at. Did they look at outside evidence that was provided by other people when they came to their conclusion? Are they actually qualified to come to that conclusion? Are they qualified to do that kind of an assessment? But when you have a CASA on the stand who doesn't qualify as an expert, but is just giving their opinion, what do you think are the proper places to challenge those opinions? It's a very powerful place to be.
You could probably ask the CASA to back it up with some evidence, where the CASA could present something to the court that makes her, I know it's a lay person, but you could provide some facts to back your opinion up.
And I spot on, right? But how do you get those facts?
Well, with some written documentation, this is what I have seen, or this is what.
Right. So the CASA goes out, or the child advocate goes out and collects that information.
Or the parents have told me this, and this doesn't really sound quite right. So I would back it up with that. That's it.
Yeah, I really appreciate Nancy and Mary's comments about you could say an incomplete job or just state the facts. They didn't meet with the child, hasn't talked to providers, right? Not making a characterization.
Mm-hmm. Yep.
I appreciate that. That's right. And that may sound better. It sounds better to you. It likely sounds better to the judge. Attorney.
Absolutely. When you're going after a child advocate, the very first thing that happens is the judge usually cuts you off at the knees. They're protective of social workers, but really protective of the volunteers, at least from what I've seen. Are we ready to go to the next one? Anybody have anything else to say about this? Oh, time. Are we done?
No, I think we go to 4:30.
Nope. Ryan's given us the sign.
Oh, we're now. Oh, it said, oh, I thought it said, oh, good.
I know
All
there
right.
was a typo. It was 90 minutes for these sessions.
I thought so. And then, yeah, okay.
Sorry.
That's okay.
Yeah, I only told my story about Sir Brome just to get us to 2 hours.
Oh, I'm sorry.
I'm kidding.
Any parting thoughts?
Jacob and Brett, if there's like one sentence you could share with us that what you would like us, one thing we could improve, what would that be?
Ooh.
That's like the $1 million question.
Right?
Yeah, yeah. Well, I can I have two?
Sure.
One, I think you guys are in a phenomenal position to press the department to fully do their job. And that looks like early services, early engagement, having a really clear plan for how the family gets to where they need to get to. You guys are in that, it's such a unique position to be able to say to the state, no, what my kid needs is for healthy parents. And in order to have healthy parents, those parents need these things and you need to do those things. Or, my kid needs to go to someone who loves them. And here are the people that love them and care for them, and you need to go do your job to get them there. And then the second thing that I would say is, again, in your role and your position, you have this bridge, and you bridge all of us to the court and you bridge all of us to the kid. And if you guys are facile with the safety framework and having those conversations and being able to say to the department, okay, great, I understand that you have concerns, but what is the safety threat and what are the behaviors that need to change and how can we put a safety plan into place to have this kid back home? And the court's going to order what the court orders, but if you guys are pressing on the department to do that, it's way more likely to actually happen.
Thank you.
Thanks for asking. That's an awesome question.
I'm like, the first thing that I immediately thought of was I started going through my checklist of things that I wanted to see improved. And you guys have done it. And a lot of my stuff is old, but I mean, you've done it. I think Ryan trained you guys, just does a phenomenal job of training you. And so that's where I went just immediately to. Glad you want to keep improving. That's awesome. And Jacob, I thought gave a good framework, but I just wanted to acknowledge the work that's already been done.
Yeah. Absolutely.
Thanks.
Hey, Brian, thanks for inviting us back.
Thank you.